Welcome to the History of Social Change Conversations, looking back, looking forward, where we sit down with experts for an in-depth discussion of an historical event that shaped Canada in important ways. These conversations are integral to our mandate of exploring our unique history through the lens of social change, and they're central to our belief that we cannot fully understand who we are as Canadians without knowing and learning from our past. Today, we're exploring the 40th anniversary of the Canadian Charter of Rights and Freedoms. Proclaimed on April 17, 1982 by Her Majesty Queen Elizabeth II, the Charter has played an important role in addressing the inequalities in Canada and defining the values of Canadians. The document was born with the objective of ensuring that all Canadians live a life without discrimination of any kind. It outlined, among others, our guaranteed rights related to official languages, democracy, equality, and multiculturalism, as well as our legal rights to life, liberty, and personal security. Section 25, meanwhile, of the Charter also recognized and protected the rights of Indigenous peoples. To commemorate the anniversary, we are honored to have with us three prominent guests. Adam Dodick is a professor and former dean in the Faculty of Law at the University of Ottawa. He has written about and taught courses in public law, constitutional law, legal ethics, among many others. Jamie Cameron is the professor emeritus of Osgoode Hall Law School, having retired in January 2020. Over the years, she taught and wrote on various constitutional and public law issues, including the Charter of Rights and Freedoms. Kara Zwiebel is a lawyer and director of the Fundamental Freedoms Program at the Canadian Civil Liberties Association. And now on to our questions. How important is the Charter to the work that you do? A very basic general question, and I'm going to throw it to each of you if you want to answer. Who wants to go first? The importance of the Charter, generally speaking.
I can go first.
Okay, great. Thanks, Kara.
So I work at the Canadian Civil Liberties Association, which is a nonprofit organization that does work to protect and promote the rights and freedoms of people in Canada. And the organization predates the Charter and did that work before the Charter. But today, I would say that the Charter is very foundational to the work that we do and really at the heart of almost any case or issue that we are involved in. We are involved in litigation where the Charter is at issue. We address members of Parliament or of legislative assemblies when they're considering passing laws that will implicate Charter rights. And we have a big public education program, which is really about trying to get young people in particular to think critically about the rights and freedoms that we have in the Charter, and also to think about the restrictions that are placed on those rights and whether those restrictions are reasonable or not. So I would say the Charter is sort of the document that's really right at the center of the work that I get to do.
Wonderful. Great. Who wants to go next? Thank you for sharing that. Adam?
Sure. So I think that the Charter is central to my work in a different way than it is probably for Kara and maybe for Jamie, in that a lot of my work, I'm a professor of constitutional law and of legal ethics, and a lot of my work deals with the structures of the legal system or of the Constitution, so division of powers, the role of the judiciary, rather than looking at specific sections or fundamental freedoms under the Charter.
Right.
But in all the work that I do, the Charter is either front and center or it's in the background. It's such a central part of Canadian constitutional law, governance, and the structure of our legal system and our political system that it needs to be addressed and discussed certainly in so much of the work that I do in teaching and in my research and writing.
Great. Thank you. Jamie.
So thank you. And it's a pleasure to be part of this conversation. So maybe I can add a bit of a historical note because I'm the sort of the senior panelist here. So I returned to Canada from teaching in the United States in January 1984. So I was there at the beginning of the Charter's interpretation. Mm-hmm. And it was, just a heady time to be a young academic in Canada. because all the courts' interpretations, their decisions of first impression, were coming along throughout the 1980s. And I don't think I'll ever forget how eagerly we waited for each of the court's pronouncements as they came along. And of course, this was pre-internet, pre-computers. And so a paper copy of the latest decision would arrive in the Osgoode Hall Library. One of us would go down and have copies photocopied for everyone, and then we'd bring our brown bag lunches into the seminar room, and we'd huddle, and we'd look at what the court was doing, and it was a fascinating time. I was very fortunate to be of a generation. It was a fascinating time, and I would say it was very formative of my career. But the charter, I've been involved in the charter all these many years. I was actively involved with the CCLA for more years than I really should admit. It was, I think it's like 30 or something, right, Kara?
It's a long time.
There. And then, so now it's a sort of a different thing. The charter decisions are still very, very important. They're fewer in number. They're spaced out a little bit more. They raise really, really significant issues, but it's a sort of a different kind of period in constitutional interpretation than those first few years.
Right.
And so it was just, when looking back, it was just very special to be a witness at the beginning of charter interpretation.
Yeah, that's wonderful. I love that perspective. Which sort of brings me to the next question. We kind of touched upon it a little bit already, but well, sort of like in terms of, how, yeah. Has its importance grown over the years, or has it waned, or has it stayed static?
I'll start and I'll make this fairly quick, I think. There's certainly an argument to be made that it's growing in importance. The decisions might be fewer in number. The charter might be less visible than it was in the early days, because back in the early days, the print newspapers were robust. And I'd hate to admit how many newspaper clippings and so forth I still have stashed away in my office. But there was constant attention to the charter and the Notwithstanding Clause that I know we're going to get to. So it had a high degree of visibility on a regular basis in the early years. But I would say it is an argument to be made that it's grown in importance because a body of jurisprudence has built now. There's a full body of jurisprudence that defines the scope of the charter and places constraints on the government's capacity to interfere with our rights. And so that's less visible, I think, but not less important. And maybe to let others comment on this, I'll stop at that for now.
Okay, that's great. Thank you.
Sure, I can say something about that. I think, I mean, it's hard to know, the charter is pretty central for me, but it's hard to know whether that's really
right.
how it is for people who aren't kind of immersed in this subject or in the law. I do think that there's been a lot of recently a lot of interest in the concept of rights. What kind of rights do we have, and who are those rights against? And also I think probably since the charter. Since the early days of the charter, I think what government does and encompasses has probably grown, so that there's, the state is bigger than it was before. And so the protections that the charter is intended to offer against intrusions from the state are potentially sort of reach into areas that they didn't reach into before, or at least there are arguments that can be made. So I think, and especially probably, during the pandemic, there was certainly a lot of talk about rights and freedoms and about limits on those rights and freedoms and what those mean. And so I think, I think probably the charter maybe wasn't as central in that discussion as it ought to have been. I think there was a lot of discussion that was sort of divorced from the reality of how rights exist in our constitutional system in Canada. But I do think that those ideas are really important, and and having discussions around them, that we've had more of those in recent years.
Yeah, that's actually a good point. Thank you. Adam, what would you say about that?
I would approach the question in this, which is, I think that the recognition of the charter's importance has changed or in different ways. And I think now you have, public opinion surveys consistently over the last 20 years have shown a high level of awareness of the existence of a charter among Canadians, really from coast to coast. People might not be sure about what the content of specific sections are, but they know that we have a charter. They know that the charter protects their rights, and they strongly support that idea of a charter. So the charter very, very quickly has become a key element of Canadian identity. And Canadians identify with the charter. They support and like the idea of a charter. And I think that that's something that has now been entrenched in our political consciousness or in popular discussion. And so, to Kara's point about people being more familiar with rights, I agree with that completely. And you see that, whether you see that in, kids' reactions to things that they think are unfair, or in political discussions, or during public health emergencies. And, again, I agree with Kara that there probably wasn't enough discussion about the charter during COVID. But, that's how I think maybe the charter has, or approach to the charter may have changed over time.
Okay.
If I could just add one little comment, sort of further to both Kara and Adam. I mean, I think many people would be surprised to learn or discover that the charter, when it came into existence, was actually quite controversial. There was a community of opponents to the charter, and they did not give up once the charter was enacted in 1982. And so, again, if you were to have the opportunity, it's quite fascinating to go back and read the newspapers and look at the reaction to the court and look at the scholarship, even through the 1990s. I mean, it was a fairly, I think turbulent might be too strong a word to use, but the court's powers and the court's exercise of its powers to protect rights were not taken for granted by everyone. And I think both Adam and Kara are right to say that we're past that now. And though Canadians have been in favor of the charter throughout, it's a different kind of a situation now. And some of that early generation opposition has, I wouldn't say it's gone away, but it's diminished, certainly.
Okay. I can get into another follow-up question with that. I mean,
if I can briefly follow up on that I think, this is a program about history of social change, and Jamie's comments remind me that opposition to the idea of a charter came from both the left and the right. And there was a lot of skepticism on the left for champions of labor, champions of progressive social change, about what the impact would be of a charter that in effect transferred power from the elected representatives to the courts, because organizations like the Canadian Civil Liberties Association before the charter had achieved most of their greatest victories for social change through the elected legislature, right? Through the enactment of anti-discrimination codes for housing and in the workplace. And the courts had really not been the friend of the worker, the common man or woman. And there wasn't a lot of progressive social change that happened under our courts pre-1982. So, again, that's something that I think has changed. There has been a lot of social change, and we'll probably get into that has taken place under the charter through the courts. But that certainly was not obvious in 1980, 81 when the charter was being debated, or in 1982 when it was proclaimed.
That's really, I think, an important perspective, because a lot of people just think it's sort of part of life and it's always been there. A lot of people don't realize that there was that whole evolution and that back and forth sort of cautiousness about what it might actually mean and what it would do to our lives. So that's interesting. Thank you for sharing that. the next question is sort of a tougher. Sorry, Kara, did you want to say something? You're okay. Okay. I think it's a tougher question, but I purposely put it out there. Name a charter case or two, whatever you'd like, that you believe has had significant impact on Canada and Canadians and the way we live our lives. So that's a huge question. And I'm curious what you might choose and why. So, Jamie, do you want to go first on that one?
Okay, I can put a candidate forward. I hear my dog barking a little bit in the background. We'll hope he stops.
It's okay.
The one that really comes to mind, and I don't know whether Adam and Kara have the same one in mind as well, but I think one that's just very visible to the public and a very, very high impact charter decision is Carter versus Canada, which is 2015. It was a case that struck down the criminal code prohibition on assisted suicide and began the whole evolution toward regulations that define and allow forms of assisted suicide. I think that, there's all kinds of decisions that we could pick out in the criminal justice system on equality, on Indigenous issues. There's just so many. But to my mind, one that just is sort of a flagship decision of the court that has potential application to all Canadians because we're all in a position where we're hopefully going to grow old and or have health problems that put us in extreme circumstances. And so it's a decision and a vindication of rights that I think has a huge significance for all Canadians. So that would be my choice, my number one choice right now. If you ask me tomorrow, I might pick a different one.
That's all good. Thank you. That's a good one, though. I like that one. Kara, would you like to go next?
Sure. I had two in mind, and one of them was Carter. And the other one is the Morgentaler decision.
That was my number two.
So the Morgentaler decision is a decision that struck down the scheme that we had in our criminal code, which regulated or prohibited abortions, except where they were approved by a therapeutic abortion committee of a facility. And I guess it's maybe the case that's significant, but also the response or arguably kind of lack of response by the political branches to the decision, because the government didn't try to, tinker with or replace or modify the regime. They decided not to put abortion in the criminal code. And I guess particularly now, thinking in light of the more recent developments in the United States, I feel like that's been that's a very significant moment for Canada that's had a long-lasting and, in my view, very positive effect. That we, at least our law generally treats abortion as a healthcare issue and not, a matter of morals or ethics or a criminal matter.
Which is an important distinction for sure.
Yeah.
Thank you. Adam, you're on mute. Oh, there you go.
All right. Okay. I'm going to go maybe a little bit off the board here. I thought of this. I'm going to offer two decisions as well.
Yeah.
The first one is a case called Andrews out of BC from 1989. And that was the first equality decision, right? The first time the Supreme Court was interpreting the equality provision, section 15 of the Charter. And, the case on its facts was pretty straightforward. It involved a claim by a lawyer who actually was South African. He wasn't a Canadian citizen. And at that time in BC, you had to be a Canadian citizen to become a lawyer. And he argued that that was discriminatory against non-citizens. And that claim was accepted. But what's more important is the foundation that the court laid for interpreting the equality provision. They could have taken a narrow approach, what we call formal equality, that equality just means treating everybody the same. So you have a rule, as long as everybody is subject to that rule, that's fine. But it adopted a much broader approach called substantive equality that says you've got to take into account people's differences and the different situations that they're in. And really that broad approach, I think, laid the foundations for so many changes in Canadian society. So, an example, it used to be really common to have minimum height and weight requirements for police officers or for firefighters. Now, on a formal basis, that's treating everyone the same, to say you've got to be, 5'9" and, at least 170 pounds or whatever to be a police officer. But the impact of that would exclude a lot of women, regardless of whether they were capable or not of being police officers or firefighters. And it also had a disproportionate impact on certain ethnic groups. And I think because of Andrews, we don't hear about those anymore. They're all gone. Mm-hmm. And I think the approach that Andrews took really also laid the foundation for one of the areas of the greatest and I think the fastest social change under the Charter over the course of the last 20 years, and that's in the area of recognizing LGBT rights. The second case that I want to offer up is a bit of a sleeper case in that it had a big impact at its time, but it's now, I think, a bit of a ticking time bomb, and that's the Ford case from 1988, which was the first time and the only time that the Supreme Court weighed in on the use of the Notwithstanding Clause. And there wasn't much discussion. When you go back to the case, there's not much discussion about the Notwithstanding Clause. Most of the discussion was about the area of Kara and Jamie's expertise of fundamental freedoms and freedom of expression. But the court basically gave almost carte blanche to governments to use the Notwithstanding Clause, and we're seeing the impact of that very much today in Quebec with Bill 21 that restricts the wearing of religious symbols for public services. So that has a real impact on especially Muslim women in Quebec and others. So that's the reason why I chose those two cases.
Thank you. And I would. And Jamie would like to say something else. And just to say, I do want to get to Notwithstanding Clause a little bit more in the future, if we have time. I hope we will, because I think that's very important. And Jamie, sorry, go ahead, please.
I'm going to hold on Notwithstanding for now, because I think it'd be nice to hear all three of us on that point. I just wanted to say further to Kara's comments about Morgentaler. I mean, again, Morgentaler was decided in 1988. I think it was January 1988, and Ford was December 1988. I mean, the decisions were coming. Not fast and furious, but when they came, they were almost always blockbusters. I remember the day that Morgentaler was decided, and for years I sort of took it as a decision that was primarily important for the rights of women and the constitutional status of abortion in Canada. But I just wanted to say quickly, sort of pursuant to Adam's comments about Andrews and its importance as a foundation for Section 15 and developments about equality law. I mean, to my mind, Morgentaler is an incredibly important Section 7 decision for laying the groundwork for the interpretation of the two parts of Section 7, which we won't get into, but both the Entitlement Clause and the principles of fundamental justice. And it took a few years for the ideas from Morgentaler to evolve and to arrive in the majority jurisprudence, but it began back then because the court was really tested. I mean, Morgentaler was a lot of these decisions were a big test for the court in the early years, because they had the potential to provoke such a public reaction. And Morgentaler and Ford are two of the best examples from the early years. Yeah. Both of them very important to the foundational jurisprudence.
Thank you. Thank you for adding that. Very true. I think I'm looking at the next question. I think it's almost as tough as the earlier question, but this is why I like throwing it to other people and to see what you have to say. So do you believe, and kind of along the lines of a lot of what you were just sort of mentioning, because do you believe the Charter does enough to protect individual rights and freedoms, or can it be doing more?
You know, I'd be really interested to what Kara and Jamie have to say. I guess from my perspective, I think that generally the Charter, the rights protected under the Charter, generally do enough to protect individual rights and freedoms. And I think that's because we have adopted in Canada what we call the living tree approach to constitutional interpretation. So our rights aren't frozen or static as to what they meant in 1982 when they were adopted, but courts can develop and expand them to meet changing circumstances, such as the Carter case that Jamie talked about. I think certainly when the Charter was adopted in 1982, it was not foreseen that it would have any application to assisted suicide or to capital punishment and many other circumstances. But things sort of change. I guess the gaps that I see are not so much in individual rights and freedoms, but the two areas I'm concerned are about democratic rights, and maybe in an area of individual rights and freedoms and fundamental freedoms in Section 2. I think there's a real gap in terms of citizens' access to information. I think that's an area where we have a real crisis, especially at the federal level. And information and knowledge is power. And if government can hide behind antiquated laws and a slow process, that really harms the citizens. And there was a proposal to include a specific right in the Charter protecting, guaranteeing citizens access to information. And the response of the government at the time was, oh, we don't need that, right, because we have a robust regime, and that would never be a problem. And I think that's, there are many predictions from that time that proved right, and there are others that proved wrong, and I think that one was really, really wrong. And the other aspect of the Charter that I think is problematic in protecting rights and freedoms is, of course, the Notwithstanding Clause.
Which we will get to. I'm sort of leading up to it with these questions. I'm trying to anyway. It's not always so intuitive, but because it's easy, we want to get onto that one, I know. Kara, why don't you go next?
Sure. Yeah. I mean, so I will park the Notwithstanding Clause for now. I mean, it's funny when I saw the question, does the Charter do enough to protect rights? I part of me wanted to say the Charter doesn't actually do anything to protect rights, right? It all depends on the actors that interpret it, and right. And I guess that's kind of ebbed and flowed, and always does ebb and flow in terms of the breadth and scope of protection. I think even, and I totally agree with what Adam said about access to information, and that's a real problem that we have in Canada, probably across the country, but at the federal level for sure. And there is a Supreme Court decision that tries to tie the right to information to a right in the Charter, to the right to freedom of expression under Section 2B. But it's not been interpreted in very robust ways. Even in the case where it was recognized, it was sort of recognized that maybe this exists, but it doesn't exist in this case. So I think a lot depends on, on what you do with it. And similarly, one case that we didn't talk about in the really important cases, but one that I think is a really vitally important Charter case is R versus Oakes, which is the case that, sets out how you consider whether restrictions on Charter rights are reasonable and justified. And the way that courts interpret that, even though, the Oakes test that was established in that case on paper has kind of largely remained intact for decades, in its application, it's varied quite a bit, and courts, will dial up the deference given to governments in some cases and dial it down in others. So it's really, I guess, about the actors that are charged with interpreting, including including the government. I mean, we were involved in a case many years ago that was about what kind of diligence does the Justice Department have to do when it's, looking at a law that's a bill that's about to be tabled and its compliance with the charter. And the way that the Justice Department looks at it is basically, is there a chance that this will survive charter scrutiny by the courts? Not even, is there a good chance? Is there a strong chance? Really, just is there a chance? And that's not a very, robust idea of what the charter does. So I think that it's not so much about what's in the text or what's missing from the text, but more about how the actors that interpret it do their job.
Okay, great point. Thank you. Jamie, what would you like to say about that?
Well, I would say first to reinforce Kara's last point, which is that the charter applies to and binds legislatures and the different government actors. And so when you ask, has the charter done enough? You might subdivide that question and say, have the legislatures done their part in being sufficiently vigilant and mindful when they're enacting legislation that can encroach on and violate charter rights? So different people would answer that question differently, but it's a really key point that Kara raised there. I guess I would also say, I have on this enough or not, I have a lot of quibbles with many Supreme Court decisions, but I'll just point in more general direction to areas under fundamental freedoms where there is underdevelopment and a complete gap. So the complete gap is Section 2C, freedom of peaceful assembly. As Kara and Adam know, this has been on my mind because of the public inquiry, but that's a vital charter guarantee that has had almost zero development. And I think I have some ideas why, which aren't really important here, but just to say that if you look at the last 10 years of Canadian history, you could list any number of public gatherings and assemblies that have a protest or demonstration element to them. And yet, this is an area of the charter that is undeveloped. The other provision under the fundamental freedoms is Section 2D, freedom of association, which regrettably has been sidelined as a general guarantee and reserved in practice, if not in principle, to labor relations issues. And I've always had a problem with that. Last thing I'll say is that, and I think you're going to ask us, or maybe we'll have a chance to comment on how we change the charter. But one of the areas where I think we're going to see increasing traction in the charter is on positive rights, and in particular, the sort of the Section 7 security issues like food security, shelter security, environmental security, water security, all those things. And maybe we'll get a chance to talk about it later, but just in the last week or so, there was a fairly important decision in Ontario that disallowed, was it Waterloo? I think it was the city of Waterloo from from taking down or prohibiting homeless individuals from property. So these issues are going to become, in my opinion, more prominent. And we'll be asking the question, should the charter be going into this area? And if it should, is it doing enough?
So yes, Notwithstanding Clause, receiving a lot of attention these days. I mean, there's various ways that I wanted to sort of approach this. I'm going to sort of leave it to you people to the experts to discuss it in greater detail. But I was wondering if it's actually being used according to the spirit with which it was drafted, and is this how the intentions behind a Notwithstanding Clause, or do you feel it's being misused? Yeah, I wonder if this is what we were, or would you actually say, and I'm just going to go on a limb here, that it shouldn't be there in the first place, as some are arguing. And those are the basic general questions I'm going to throw at everyone. I was really excited about this question. So, Adam, do you want to start with that one?
Sure. I think it's a tough question, because I'll answer the second part of your question. If we didn't have the Notwithstanding Clause, we would not have had a charter in 1982.
Right.
I think that is a political reality. It was a political compromise. Maybe we would have got a charter, a different charter, a number of years later. Maybe, maybe not. But certainly at that time, Pierre Trudeau had been prime minister since 1968. He had been pushing for a constitutional bill of rights since he was minister of justice in 1967. He had briefly got agreement on what we might call a mini charter in Victoria in, I think, 1971 or 1972. That lasted a week before that broke down. There was a decade of discussions. There was, reference to the Supreme Court of Canada that couldn't get the provinces on board. And finally, what got agreement from 9 of the 10 provinces was the inclusion of the Notwithstanding Clause. So that's why we got a constitution. That's why we got Charter of Rights and Freedom, etc. So it's hard to, we've got to. I think we've got to live in the real world and recognize that, in an ideal world, we could add all of these rights to the charter. We could take away the notwithstanding. We could do many different things, but that's the sort of reality. To the first part of your question, is it being used, in according to the spirit with which it was drafted or according to its intentions? I think that's a hard question because the reality was there was very little discussion about the idea of a notwithstanding clause during that decade of hyperactive constitutional discussions. So like behind me in the books, I've got books full of drafts of constitutional drafts from the 70s and early 80s. Like none of them included a notwithstanding clause. There had been some talk at some meetings, but we really don't have a lot of discussion. There's a guy named Charlie Feldman who now is a lawyer for the Parliament of Canada, and he put together all of the discussion about the notwithstanding clause from 1980, 81, 82. It's barely 10 pages. There was very little discussion. Right. That being said, and I think that's important to sort of put that out there as a caveat. That being said, the limited discussion that there was about the notwithstanding clause was that it was envisioned, and I'm trying to choose my words carefully as opposed to intended or a collective intention. People, political leaders like Minister of Justice Jean Chrétien, like some of the different premiers or provincial justice ministers, talked about needing a safety valve in limited circumstances when to respond to court decisions that they felt were out of touch with political reality. And that concern, again, came from the left as well as the right. There was a concern that what would happen if the courts would strike down legislation expanding, progressive social change or trying to block progressive social change. And there were concerns on the right in a different direction. So, I'm not sure the court has read Section 33, the notwithstanding clause, in a very literal way. And I don't think that is consistent with its interpretive approach in other areas, like fundamental freedoms, like and other areas of the charter, like equality, where it says that the court must take a purposive approach and look at the purpose of the provision or the purpose of the right. So I'll just sort of stop there.
Okay. Thank you. Thank you for that. Anyone want to go next? And also, if you wanted to talk about, generally speaking, about whether you think it's being used incorrectly today, regardless of spirit, of how it was supposed to be drafted, you can mention that too. Sorry, my dog is just...
Jamie, do you want to go next?
Sure, I'll go. So the first thing I would say, just because I'll forget if I don't say it at the top, is that if we're entertaining any thoughts of getting rid of the notwithstanding clause, we have to bear in mind that it is difficult, if not impossible, to amend our Constitution at this point in time. So that's not to say that other steps could not be taken to constrain the override, whether it be legislative in nature or even sort of evolve as a matter of constitutional convention. But constitutional amendment is a very difficult proposition. So what's interesting to me about the override is, as Adam says, there's not a lot of discussion before 1982.
Right.
Bingo, it's there in 1982. And if you, again, because I'm a child of my generation, if you were to go back and look at the discussion about the override from 1982 through to almost to 2000, it was closely watched and often debated. And there was a constituency that called for legislatures to feel free to use the override to respond to the powers that the courts were exercising, or to prevent certain kinds of issues from becoming justiciable and the subject of constitutional interpretation. But then the override went sort of quiet around, or well, I'm just saying ballpark, around 2000. There was a period in which Canada's override was put forward by its own academics as evidence that Canada had found sort of a eureka moment in constitutional modeling, because they hit the halfway point between judicial supremacy and legislative supremacy. And so the override made us look good under that view of Section 33. And then we come to more recent times where there's a lot of discomfort, if not outright opposition to the way the override is being used, in particular by the legislatures of Quebec and Ontario. And I guess it's just to remind everyone that the override has had its own sort of ebbs and flows and so forth. And I think that's likely always going to be the case, because it's a creature of political dynamics and political culture. And the worry I have is that, of course, the same one that others have expressed in recent years, and that is that once it becomes legitimate to use it in this case and that case and this case and that case, then that opens the door to it becoming a more routine way for governments to deal with the potential scope of the charter and its constraints on their own actions. And I don't know whether I'm sort of segueing to use, Kara. I don't know if you want to talk about the Ford government's retraction of its notwithstanding clause. That's a good example a couple of months ago.
That's a good example. I was going to say Ford, and I was also going to bring up again Quebec issue, but with Ford, I mean, whatever you want to mention that brings it into practical significance.
Yeah, so I think I think Quebec is sort of its own case, and like Adam said, right, we have to appreciate that we wouldn't have a charter without the notwithstanding clause. And I think if we tried to amend it now and remove the notwithstanding clause, we wouldn't have Quebec, right? Like right. Quebec sees this as a very important tool, and so like it's the reality. I think that we are stuck with it. I'm not even sure, frankly, if I would want to get rid of it. Like Adam said at the beginning, when the charter was being debated and discussed, the Canadian Civil Liberties Association was skeptical about this idea of an entrenched Bill of Rights, and Alan Bourvoy, who was the general counsel for 40 years of the CCLA, liked the idea of a notwithstanding clause, liked the idea that ultimately Parliament would get the final say on certain things. I don't think he would have anticipated it being used in some of the ways that it's been used now, and I think he would find them really problematic. So I think you have to sort of treat Quebec a bit differently when it comes to the notwithstanding clause. In Ontario, I think we went through a pretty scary period where it seemed like the Premier didn't think was much of a big deal to invoke the notwithstanding clause, and the old time he didn't get what he wanted, and he threatened to do it for issues around the Toronto City Council. He did do it in relation to electoral finance rules. So the notwithstanding clause was invoked to protect a law that the government had put in place, which restricts what third parties, so not candidates or political parties, but other people can spend in the lead up to an election. And so it's really, an attempt to sort of shrink or silence civic voices. And that law, when initially challenged, was found to violate the Constitution, was found to violate the right to freedom of expression under the Charter and not to be justified. And rather than appealing the decision, the government just passed the legislation and invoked the Notwithstanding Clause. So, the legislation is being challenged on other grounds, on the grounds of the right to vote, which is not subject to the Notwithstanding Clause. We are still waiting at the time that we're talking now for a decision from the Ontario, the Court of Appeal in Ontario about that decision. But, but Ford was quite comfortable using the Notwithstanding Clause in a situation that I think was very obviously a self-interested one. I mean, we're talking about the rules of the game that get people elected. And that's, the reason why the right to vote is exempt from the Notwithstanding Clause is precisely because you're not supposed to be able to do that. But more recently, as Jamie mentioned, the government tried to use the Notwithstanding Clause to force a contract on a group of some of the lowest paid workers in the public school system in Ontario. And they, I think, did not anticipate the backlash that they would receive as a result of that. And, there was a huge, the CCLA spoke up. The unions banded together, including public sector unions, private sector unions, the whole, people have joked that Doug Ford sort of united the labor movement in Ontario to fight against this threat, because I think everyone realized that if the government was prepared to use the Notwithstanding Clause to override collective bargaining rights in this situation, there was no reason to stop them from doing it in any other situation. And so the government, fortunately, I think was chastised and realized that this is not going to work, and they backed down. And they repealed that law. And more recently, when they got a decision from an Ontario court in the labor rights context that they didn't like, which was a decision that struck down some wage restraint legislation that they passed, they said we'll appeal. They did not say we'll invoke the Notwithstanding Clause. So my hope is that they've learned the lesson, and that it's not that they've just learned the lesson in the context of labor rights, but we'll have to see whether that's true.
Time will tell.
It's an interesting case study in the sort of the fluidity of the political implications of using the override. So I think the Ontario history of using it is quite an interesting one.
Yeah,
recent history.
Yes, thank you. Good point. I know we could probably spend hours on this topic alone, but I won't make you stay with me.
Sorry.
Yes.
Can I say one more thing?
You can.
I know I sort of put Quebec aside and said it's a different, we have to treat it differently. But I mean, as far as, do we want the Notwithstanding Clause out of the Charter? There is, to me, something that is deeply, deeply troubling about the idea that we have an entrenched Bill of Rights, and yet we have a province that has said that if you want to work in certain public service jobs, you cannot practice your religion in the way that the way that you think is required. I mean, it's hard to reconcile that with the idea that we are a liberal democracy.
Agreed. Sorry, that's my opinion. That's just my personal opinion. And you ask, we can sort of, if you want to say anything else more about that, anyone, that's wonderful. I do know that we are kind of running out of time. So if you wanted to say that within the last question, which is, I'm not going to ask to explore very deeply because of the time, but with that being said, or with anything that was said on this panel, what do you think in terms of the Charter in the future? Like, do you feel it's going to continue playing this important role? Do you think, is it going to increase in importance, or anything you wanted to say about that? And you don't actually have to either, because we are running out of time. So up to you. Is there any other thoughts or you wanted to add to this conversation? Anyone?
I would only say that U.S. experience, if we look to the South, will show us quite dramatically and usefully that the Constitution is always a factor in the life of the democracy and the evolution of a democratic community. And so it's never the case that all the questions have been answered, never the case. And so I think we'll see, we'll look to see how the charter evolves in the future.
Okay, thank you. Adam, would you like any final thoughts on that?
Sure. I certainly don't think that it's going to like wither away into irrelevance or actually reduce in relevance. I think it's proved remarkably adaptable to new situations and to addressing new challenges that weren't in existence in 1982. So whatever future sort of lies ahead of us in terms of environmental threats, climate change, AI, etc., I think that the charter as an instrument is well placed to be able to address those issues. I worry that given the decline in, let's say, political morality or the decline in respect for unwritten understandings, more and more things will be pushed up against to the letter of the law, kind of like what Kara talked about with what's happened in Ontario, which is an approach, I think by the Premier of Ontario saying, well, I have this power, well, I can just use it. And so as opposed to self-imposed limits by political actors, whether that's the police, whether that's the police aren't a political actor, but by government actors, whether that's the police, legislatures, premiers, cabinet ministers, etc., and that will put more and more pressure on using the charter as a shield against government action. More and more challenges for people like Kara and for important legal theorists like Jamie in order to either protect against those situations or come up with cogent sort of theories about how the charter should work in those circumstances.
Thank you. Well said. I know we're already a minute over, but Kara, if you wanted any last thoughts.
Yeah, I don't know. Everyone has said, has articulated everything so well. I'm not sure I can improve on anything. So I agree. I mean, I don't think, it's not going anywhere. It's going to have to address the challenges that we're going to face in the future. And I think some of those areas that Jamie and Adam have mentioned, the technology and but also access to resources, to housing, to food. Those are things that I think our courts will have to address. And also I think, the charter stands to play a really important role in how the relationship with Indigenous communities in Canada evolves and changes. So I think the charter's got plenty of work to do.
Okay, great. So I wanted to thank you so much for taking the time. It really means so much to me and to this project. Thank you. Everyone take care of yourselves.
Thank you.
Enjoy
Thanks
the
for
day.
Very much.
including me.
It was lots of fun. Bye-bye.
Great,
Bye.
thanks.